Dear students, let us start the discussion on today's newspaper, that is 30th June 2017. The first article, the task before the sentinel. This article is written in the context of the Aadhaar. You know that Aadhaar is being passed through money bill route. So what is the major criticism and what is the role political parties and judiciary is expected to play in this law? That's what we are going to discuss over here. Remember a few words over here. The rights are not meant for economic exchange. And second is, the state cannot take away the privacy of the citizen. Any surveillance of the state over its citizens, it builds the mistrust between the citizen and the state, which is not good for the stability and order in the society. So based on these points, let us talk about this. The first is, Aadhaar is supposed to confirm an individual's identity to deliver a particular benefit or a service. So it was actually meant for streamlining the public service delivery. But today, Aadhaar is made mandatory for everything. This is leading to accumulation of the data with the government, and government can take up the surveillance against the citizens at a click of a mouse. And other challenges such as data leakage and cyber security related challenges exist. So in this context, what we shall do? So, it is violation of the fundamental rights. The question before the Supreme Court is, the right to privacy, is it part of the Article 21 of the Constitution or not? Earlier, Supreme Court has clarified in MP Sharma case and also in Karak Singh case, MP Sharma case and Karak Singh case, the right to privacy also is part of the Article 21 of the Constitution, but the government has asked for a clarification on this. Till date, the Supreme Court bench did not deliver any judgment on this part. So it is referred to the nine judges bench, and the matter is pending before them. So then what is the way out on the state surveillance? Political parties' power is not guaranteed. They may stay in power today but may be moved out of this tomorrow, because Aadhaar is conceptualized by the Congress and it was out of power now. So that's why the major opposition for the Aadhaar shall come from the political parties rather than from the civil society. But political parties are not taking active interest in fighting the Aadhaar, that is what is the concern. So judiciary has a responsibility to protect the constitution. It may need not see the legislature in the bad light, but as an institution meant to protect the constitution, it is expected to act swiftly. That is what this article's essence is. Making the house rules. This is about privileges of the house. Now the privileges of the legislature, these are not codified. There are two articles which deal with them, that is Article 105 with regard to the privileges of the parliament, 194 with regard to the privileges of the state legislature. Actually, legislative privileges have come in Britain. So there, the legislature is expected to protect itself against the monarch or powers of the executive. So that's the reason why it was stated that the privileges of the parliament, they include freedom to speak in the house. And these privileges later were not only extended to the house but also to the members. So, the objective of the privilege is to maintain the independence of the voice of the members of the legislature and also to maintain the dignity of the house. This is how it is being believed as. So, the second point, the privilege is meant to maintain the dignity of the house. It is giving a lot of scope for the misuse of the privilege motions. So recently, if you take, in 2003, Hindu editors were supposed to be arrested as they have used certain words which are not expected to be used against the house, such as diatribe, etc. So the privileges or lack of codification of privileges is ultimately leading to unnecessary discretion to the legislature. So if you take UK, though there are privileges to the legislature from 1880 onwards till date, these are not being used. Australia, it has passed Privileges of the Parliament Act to codify and to clearly define what it can possess. So today it is like this. The privileges are meant to protect the independence and freedom of speech in the House, and these are supposed to exist only for the House. and they need not be extended to the individual member. If individual member or his respect or dignity is being lowered, he can go to the courts under the criminal defamation. So that's the reason why what we can say is law has to be codified, members can be excluded, and to that extent the privileges motion has to be applied only when freedom of speech of the members of the house is obstructed, not in any other cases. That is what has been stated. And the next is a welcome sale. It is about disinvestment in the case of Air India. Air India is a classical example for the mismanagement of public sector undertakings. So in this context, any PSU for that matter, it has to function when the private sector has not completely developed, because the government has no business in business. So as a market well developed, in such a circumstances, state need not guide that particular sector. It is competition which has to guide that sector. So if you take Indigo, Spice, and everyone are making profits, Air India is having a debt burden, and this debt burden is increasing. So government has no business in business. And second is, the government shall more rely on market to deliver the services to the citizens, and government shall function where the markets fail to deliver. Especially in the sectors such as airlines, the market is well functioning, and let the matters be given out to the market. That is what is the essence of the article. The plain truth, this is related to Nepal. You know that hilly terrain and plain terrain exists in Nepal. So, Panchayat elections were recently held. In the first phase of the elections, it was in the hilly terrain. Now, Madhesis who majorly live in the plains, the second phase of the election was held. The first victory to the government in Nepal is to conduct the second phase of elections. Though the Madhesi front, that is Rashtriya Janata Party Nepal, did not participate in the second phase of elections, it was still fielded its independent candidates. And second thing is, the voter turnout is also very high. So it clearly shows that the people are believing in democracy, but it shall not be a reason that people have accepted the constitution, so no amendment is necessary. It cannot be judged that way. So in the first phase, in hills, it is Communist Party of Nepal United Marxist Leninist has got the majority, and obviously Madhesi parties are expected to get the majority in the case of plains. But remember again, the federalization, restructuring of the state, providing for greater representation to the Janjatis, these will provide for a stable Nepal. That's what India believes in. Next, coming to the open-it page, should the sedition law be scrapped? Remember a few points over here. Conviction rate under the sedition is very low, but filing of the cases under sedition law are very high. It means most of the cases are frivolous. In India, it is not the punishment which is really feared for. It is the legal process that is feared for. It means under the fear of the complex legal process, the opponents are made to bend down using the instruments such as sedition law. So it is the most misused law in the country. And second thing here, we need to remember one point. A misuse of the law cannot be a reason for the repeal of the law. We shall be able to correct the problems or misuse which is happening. And second thing, most of the times sedition law, defamatory laws, these are goes against to the freedom of speech and expression. So to an extent, sedition law is today used against a section of the people. It is leading to criminalization of the entire society. And if you talk about Dalits and scheduled tribes, displaced population, against them the sedition law is most used. So if you talk about a village in Tamil Nadu, who have questioned the Kudankulam project, entire village has faced the sedition charges. And similarly in Orissa, the people who are agitating against the mining, on them the sedition charges are being framed. So what is a true dissent? What is an anti-state action? It has to be clearly defined. You know that the sedition comes under section 124A of Indian Penal Code. According to this, anti-government action, anti-state action is also under the definition of this sedition. The Supreme Court tried to define this. The Supreme Court in Kedarnath Singh versus State of Bihar has clearly stated that just using rage or else words cannot be a reason for filing a sedition case. It shall incite violence, immediate violence. That shall be the reason for imposing the sedition charges. So in this, the definition is very clear. So the state shall have the patience not to judge every action as anti-national, anti-state to impose the sedition charges. That's what we need to keep. And then the cutting tribunals to size. So if you take this year budget, it has tried to rationalize the tribunals. It means it has decreased the number of tribunals. So that is, from the efficiency concern, it is very good. But the other side, the tribunals are expected to autonomous bodies. If the government is able to make their shape, structure and personal practices, where is the autonomy or independence of the tribunals in India? If you take United States of America, where the tribunals have come into existence, they enjoy the true autonomy, but that is not the case in the case of India. Let's come to the front page now. Rawat in Sikkim as China demands troop withdrawal. So this is Doklam dispute. What is this? This Doklam is a plateau region between India, China, Bhutan. And this Doklam is under the administrative control of the China. And Bhutan claims the sovereign rights over this Doklam region. And there is an agreement between China and Bhutan that tranquility has to be maintained across the borders. Now China is trying to build a motorable road till the Bhutan from this Doklam plateau. And second is Chumbi Valley. It is a very sensitive region for India. It is just very close, some 60 kilometers close to our Chicken Neck corridor, which connects India, northeast India with the mainland. So the Doklam is strategically very important location. India had temporary bunkers over there. These are destroyed by the Chinese. This has led to a standoff between these two. And China claims that India has crossed the border and stopped the Kailash Manas Sarovar pilgrims visiting the sacred place. So in these circumstances, the General Mr. Rawat has visited this particular spot. That is what this article talks about. And then let's go to the next page. Not Dalit inclusion, but mere tokenism. So, bringing the president from a Dalit community will not automatically lead to Dalit empowerment. It is the inclusive agenda of the government, an inclusive development, justice concerns, and liberty, right to dissent, opportunities. These all will lead to inclusion. It is not just not just keeping a person to the highest office in the country. That is what Ms. Meera Kumar talks about. And after this, US stand on Hezbollah chief alarming. You know that he is declared as special category global terrorist by the United States of America. And then let's go to the next page. So here again it is Doklam Plateau. So we have discussed in detail about the Doklam Plateau. It is a tri-junction region which is under the administration of China. And Bhutan claims the sovereign rights, territorial rights over this particular region. And India also have a strategic interest over this because it is very close to our Chumbi Valley and the Chicken Neck corridor. That's what is being stated. And you know that Mr. Baghdadi, IS chief, has declared the caliphate from Mosul in Iraq. So now, entire Mosul is under the control of the Iraqi forces now. That shows the defeat of the IS. So that's what this article talks about. And then coming to the Prime Minister Modi's visit to Israel, it is expected to develop relations in the non-strategic areas. It means a partnership is expected to be developed in non-security issues such as water conservation, scientific cooperation, etc. So that's what is in the other paper. And then If you talk about the palace politics in the case of Saudi Arabia, now Mr. Naif, the crown prince who has been removed, he is kept under the house arrest as the reports we go by. That's what it has been stated. Today I am traveling, so I am unable to give you the notes. Tomorrow or by Sunday I will update these notes. Last year, this codification of the privileges was a question in UPSC, and it is a beautiful article to understand the same. And privilege or else right to privacy, this can be a question this year. What is the constitutional status of right to privacy? Are we expected to have right to privacy? This can be a question for you. Our sedition charges itself can be a question for you. Criminal defamation, is it necessary or not, can be a question for you. So most of the questions in polity, they come from current affairs itself. Thank you very much and all the best. So today is the last day. From tomorrow we are getting GST, and lax.in/test prep you have the anthropology courses. I'm happy to announce you that from the 13th of July we are starting public administration online classes, optional online classes. Already public administration test series is launched. We are going to launch the online classes for the public administration optional. Thank you very much.